Well, yeah, that's a Sawajibre or Bigim on Adum TV, and Afi Asempa on Ekosiisen. What it tells you is that Media Mahine Kwabna Santi, and I mean, Philip Osebons, Obi, Yatanasi. Yebedin Koma here, Impendo Donano, Obertina, Semia Betabontin, one Triam Bain paying for, and in Chimuya, and a lot of issues. But the Abaton and Sequa Quas and Cassia Pano, the Brunibika say emergency power supply home comma, Aquensem Bebre. Ebinim say, in Nama Horden, Ekosiisen contract, and Part Ghana here say Nama Horden, if they overbound for so they will be. Ebinim they be contract in Munanka, the Jimoko GPGs in Ankazano. Almost no for Aquamis, Bugan and Intia, and we say, Tokruda is a shame, almost fire in the room. Ebinim so crazy to say, I buy so I and Shanghai, I may need see Castle Pie, bit me a boy, I knew my baby, and near buying Kutia Ama. Yes, Jumakuno. Won't you say anything? Measurement Tias anything? Oyamadum, Ghana's Attorney General, Gofred, Damia Bois, Enyana, any metric, yes, and Kono. Mendasi for a brown Yamai.
That's a
medical first question, maybe say, I mean, I was able to abemni say, I think around 3rd of June 2015, and as a emergency power purchase agreement, you won't come a buy and Ghana is answered near what to be a bimintino. Is just a share and a boy in the GPGC and a coyer Sanshi share. Now the ATF film near different, it's implied the common, and the ATF in a quite different. A dear Potepan at the common.
Right. It's so kind of emergency power purchase agreements no around 3rd June 2015. Now in this abino, almost signing. Now almost signing was supposed to deliver power within a certain time frame. For a time frame, as only deliver power. No. By the time I ultimate agreement, now conditions precedent, as they say, no matter say 1 year as agreement, I effective now 1 year. Now, interestingly, 2016, September 2016, now NDC balance as well. One who say, signing what do we call PPA? PPA is just a power purchase agreement. I'm signing PE as a bruisel. Now, once I'm signing there, it holds financial implications for the state. So, because the financial implications is being held on account of the execution of these PPAs, there was a need to evaluate. And so, I'm share now PPAs almost any year and say, PPAs will cry, a who here say, I'm signing, the who here no, for me to cancel, and so much, and I say, maybe a who here no, but time no answering because if I'm community say I be my power supply now too much no maybe I'm waiting me defer or postpone. The committee no set up in 2016 September no. We took office in January 2017. Government they said to us civil servant public servant to be on more to continue or management no we report by April 2017. Now committee na and making the determination say most of the PPAs were unnecessary because they would result in what they termed excessive capacity development or excessive power supply to the state, in the sense that the state's capacity was determined, was limited. Even if what they kakra etoso, because we be a industrialization 1D1F power, a being a power seed manoma, what in your boma. PPAs on my sign. Bro, so cry. They say a terminate P. No, some make here the termination said they should terminate about 11 or so. And then a few others should be deferred because Osha terms are quite favorable in Tibia. It deferred best 6 years time. Because even the terms are favorable, but at this time, we don't need the power. And now, interesting, okay, so and the first PPAs a very resulting in losses to the state amounting to $586 million every year. And that is from 2018. And cumulatively, that is totally from 2018 to 2030. A very resulting in cumulative losses of 17.6 billion, if I'm over $17 billion. Then Papa say maybe I say you try even if you be a bank care loss that. To the committee and realize say yes, termination there to come with financial implications. Because NDC are banner signing agreement with Gofred. Now Gofred na sign agreement with them. So we agreement na. But we should terminate here. Say what you power, say one GO. So to be. And that's really my problem. Later on, I'm sure say be uncommon at Beko. So that recommendation was made to the government. Say we won't cancel some of the PPA agreements, including GBGC. The GBGC agreement, no, we can specifically say that agreement ought to be terminated. And so the Attorney General at that time, Madam Gofred, also relying on the report of the PPA committee. I say PPA committee because I was supposed to review PPAs. Also reviewed the agreement and made certain determinations that, well, in addition to the lack of excess capacity, in addition to the fact that the agreement would occasion excess capacity, the conditions precedent and some other conditions.
Okay,
subsequent.
but Mr. Obi, my main intino will be saying, sir, committee na is setting up no. This administration or the previous administration?
The previous administration. And
reason being? Because
Omansa who say there was an existence too many PPA agreements. PPA agreements, no, very resulting in what we call excess power. Say, electricity in here, power in here, Ghana. Into in here, so they are say a very waste, and it to not just be waste, but of course it will also result in financial loss that the state was going to lose. I think it's quite, if I may actually quote, just for purposes. So the first issue, and this for a move away from say a committee no your time set up. It's quite clear here. The committee was inaugurated on 29th September 2016 by the Chief Director of the Ministry of Power. That's at page 12. Then you go to even the same page, page 12. It says the action has become necessary as the setting up of the committee has become necessary in view of efforts being made by government to ensure that adequate and affordable power is made available to a citizenry. This is in consideration of the need to procure adequate power as and when required and avoid excessive capacity development, which leads to increased capacity charge payment.
Wow.
Until once I find out, say, really, if they don't evaluate the PPAs now, a bit and that it is informed by the need to procure adequate power and to avoid excessive capacity development, which would lead to increased capacity payment. So that's really the rationale for setting up the committee. Now, on the question as to what would happen if the agreement or the agreements were allowed to proceed, the committee also made the determination here. In the business as usual scenario, where all executed PPAs are made to proceed without modification, excess capacity rises from a minimum of 524 megawatts in 2018 to a maximum of 2,886.85 megawatts in 2021, when all the committed and candidate projects would have reached their commercial operation date. Over the period from 2018 to 2030, the annual excess capacity average 1,400. That's excess capacity.
Yeah.
So the annual excess capacity averages 1,463 megawatts, whereas what the country needed was 524. So the country needed 524 megawatts, estimated high. Meanwhile, excess capacity alone was 1,463. That's about
PPAs and assigned.
Yeah, assigning. That's about 300% more. So the country needed 524 megawatts. And that's a excess. Alone is 1,463. There was a need for you to continue with the business as usual. And the annual cost of this excess capacity averages about USD $586 million. The annual cost
every year
from this excess capacity average, not the one that we be using.
Yeah. Excess capacity.
Yes, capacity averages about $586 million. This was the result or the finding or report of the committee set up by the Ministry of Power Minister of Power.
And
then,
for the purpose of Incommodity,
yes.
the Ahinkra Committee, because
Okay.
Dr.
Ahinkra,
Energy
yes.
Commission.
Okay.
Or
chair.
Yes.
I think there is really no debate about said the honorable the rationale for why this committee was set up, because also the findings of the committee now in the executive summary has said the committee established that even though capacity additions will be required in the years to come, the scheduled capacity addition from the executed PPAs is in excess of the required economic and sustainable capacity additions, which even include the 20% reserve margin. You know, the 20% reserve margin, still, but I think so. What do you know? You can establish the debate be anyhow. The said your former boss advised the energy ministry say based on our report or more and cancel contract but say OSHA report and so recommendations on a GPGCD the report can say government may consider terminating the PPA of GPGC with an installed capacity of 107 megawatt at an estimated cost of 18 million USD, or else pay excess capacity charge of 24.90 million USD per annum over the contract period of 4 years. By the time our report we are ready, our committee recommend say we may terminate. Now ye name say the company in question na start here adwuma bi kakra, for which reason I intimi nka say yes sorry terminate contract no sa keke.
But we'll be checking. Is it May?
Yeah, May.
You read that
but
May.
Yes, but government may because the committee was recommending something to government of Ghana.
Their recommendation
Was up to the government of Ghana to take or not to take. I mean, essentially, but it also did not derogate from the point that the committee had made all these findings that you could not ignore.
Yes.
If you are a responsible government, you're supposed to take decisions based on informed situations. And the information that we had received was that these PPA agreements were unneeded, apart from not being needed. They're going to result in losses of about $586 million to the state. I mean, country, even George Walker Bush Highway at that time, the media account was 544, which was 543, which was celebrated. And so if every year we're going to throw away $586 million, really that is something that any government cannot ignore. So on account of that, the government decided to terminate, and that was of course preceded by the opinion of the then Attorney General. But I'm saying that, yes, back to your question whether we are not established that work had been done and all. There was determination by the energy experts at that time that really not much had been done. And I think that if you read the arbitral award made it quite clear. Say, our witnesses testified to the fact that work had not been done. Of course, the arbitrators held a contract review and determined that yes, we were supposed to pay this amount of money. And I'm saying that it's to be beside when say, Adena agreement almost supply power at all. Adena agreement what was termed conditions precedent. Say normal engineer. I don't know. Good. You go a agreement no agreement properly. Adena say it mutual 1 something million to a company who had not done or which had not satisfied all those conditions precedent. And that is because of the kind of agreement entered into by the NDC. So apart from the decision to enter into the agreement itself, we must also probe the very terms of the agreement that were entered into. I don't know if I'm making myself clear. So first and foremost, 2 factors expose the government of Ghana to the payment of this amount of money. First was the decision to enter into the agreement when was the conditions really did not render the entry into the agreement necessary at all. What for argument to emergency power agreement? Emergency say unya power for use. Meanwhile, by 2017, now conditions present no, they are satisfied. agreement which I say says as far conditions president.
And Sama.
Yes, very short time, about 30 days or so.
30 days.
Yeah, 30 days. Signature of the agreement. So he was supposed to satisfy it. By 2017, by the time you existed, you signed it on 3rd June 2015. You exited from power
7th
in
January.
yes, January 2017. By that time, there was no condition. I mean, there had not been the achievement of an effectiveness of the agreement. So even by that time, they should even have perhaps terminated the agreement, because first and foremost, all the conditions present, the timelines had been, had not been honored, and also that by that time there was no emergency situation. Some would do something before,
Yeah.
And even on account of the PPA committee report, by September 2016, there was excess power. So it means the emergency situation, regarding the agreement itself was not existent.
Wow.
That is one. And I'm saying that why would a person then saddle the nation with such unjustified financial expense, financial loss?
So agree with so we share some of the condition precedent and I was say omo meeting na e be a binding and was say provided. And for example, bakone license and I was omunya from the Energy Commission. I be mo kwai mo trade in power na ade no. Sa license na say e dali ya omo nsa anka. Permit ne ade na omo pay to enter site and begin construction. And no na akwa akoye bibia e wo ho. Enti the company also feeling say, okay, by 2017 I'm satisfied, but it was not my doing. It is a obe cancel contract based on say, any idea was a mayor, then no knows woman a problem.
Fair argument to make if I were a lawyer for the company. Yeah. But I'm saying that the government, which was responsible for ensuring a satisfaction of that agreement, reneged on its obligations. It failed to meet every important timeline. Even the time for submitting the agreement to Parliament, they even defaulted by many months. So really, they themselves, right from the outset, set out not to even carry out the terms of the agreement.
Deliberate?
I don't know whether it's deliberate or not. That's why there must be an investigation into the circumstances surrounding the entry into the agreement and the default on all the terms of the contract. I mean, I think that it's a matter that in the interest of the nation we have to probe. Now, when you know that the country did not need such an agreement, you enter into it and then later you just find I want to export it to neighboring countries. But that even is defeated by how the agreement was described. It's an emergency power purchase agreement. You entered into an emergency power purchase agreement for the purpose of subsequently exporting to another country? No. And then also, per the determination of the technical people at the Ministry of Energy, the conditions for an exportation of electricity, they don't even exist by the time the agreement was signed. If you look at the PPA committee report, I think it is made out there, stated clearly that really the whole issue of exporting electricity and whatever really did not arise at all. And I think that was a hoax. Because to date, I don't think that there is an establishment of conditions necessary for exportation of power to electricity to neighboring countries. So really, to date, this argument would have been unnecessary.
Okay.
Then to the terms of the agreement that I said were also very bad in simple terms. If you look at the agreement itself, you see that clause 1 defines what effective date is.
I know a very critical point. The time and there was a contract, yeah.
So clause 1 say court no. Clause 1 say agreement no be effective after fulfillment of conditions precedent. It says effective date is a date on which all conditions precedent have been fulfilled or waived.
Okay.
And will be 30 days from signature date.
Okay, no, just say Ghana by timia fulfill or no.
I say effect. I say agreement. No, say a big giant now so a judgment. It must be after conditions precedent.
So a bit more. So I say we know. I say timia we.
I say
within 30 days.
30 days from signature date.
From time you sign.
Except that by mutual agreement in writing, the parties may extend the period. There was no such extension in writing, and was actually part of the agreement that we used to defend the matter. That indeed the parties themselves, by their conduct, had decided to even render the agreement ineffective.
O can tweak aside the okay as it is.
Sebia in conformance and pono na bomb signing agreement no NDC for government any GPG's campaign no. Oshemumpa they really no agreement to any senka e bamukra.
We only was agreement.
Oman yes 30 days oman ye. No most agreement just say some extended time no in writing. They never did that. So it was part of the agreement that we raised, but they were shut down. And why they were shut down will be clear from the terms of the agreement. They were shut down because we call clause 2 the same agreement. Into the still went to empire. Even if appointing a holding part, stay a suit here.
You can be
because yes, because
and no your administration there can say you can be understood.
Yes, to my mounted defense for court no. And there was a full defense. Among for say case no, there was a default judgment. Default judgment say be what filed rate against me. 7 days I send my entire appearance. Now my entire appearance. You have the right to go to court and take judgment against me. So me file defense so I mean entire appearance, I file appearance. That's and so I have 14 days I say be file defense. And so my that one man file defense. You have the right to go to court and take judgment against me. In this case, it was never like that at all.
And this
agreement case no, almost Friday no. We contested the matter vigorously. We filed our statement of case in the opposition, filed many documents in the opposition. Then there was a full trial. Say you take case in your court, almost on witnesses, a buy, almost kind, and almost say we in the yes cross examine there's 5 witnesses. Dr. Henkrampo also testify on them.
Oh, okay.
Yes, a trial for us, and we proceedings are journey for 4 months, and so my judgment January 2021.
Within 2020 COVID period, no, not trial, no air cost. Meaning some way no online.
Online, yes, we're online. In Yekogu, from Olympic, from hotel a Monte, for the representatives for me. I mean, probably about here. By now, me argue and officer of president so sending man for by
reps.
Yes, Koisuman to come and observe and all that. Many other people. So really, one for make us default judgment, no. At all, okay. But of course, so mutual agreement to say a broadcast unnecessarily. Now, even though my defining say effective dates near after this president had satisfied me. Clause 2, defining the term of the agreement as starting from the signature date. That's fine. Then clause 2B, it just says term no a guaranteed period. And in the event that you terminate the agreement, see we also an agreement in there. Then next week we terminate here. So we clear all the sums that a person will be entitled to under clause 25.
But where from this?
Precisely, as you say we have a corner agreement in Into clause 2 is subject to provisions of clause 25 of this agreement. And the company is subject to this agreement shall have a term commencing on the signature date. And then clause 2B, the term shall be a guaranteed period. And in the event, so the term which starts from the signature date, a guaranteed period. And in the event that this PPA is terminated in accordance with provisions thereof, prior to its scheduled expiration date as a result of the default of any of the parties not responsible for the default may proceed in accordance with clause 25 of this agreement.
Wow. What it means is to say a buying per se even or exercising the powers under clause 1. Say more meeting condition president did me more.
Yes, indeed. The proceedings I hope said were even recorded. Which arbitration almost private. Yet I can produce to you the notes that I made for the argument. And I said that the implication of this agreement is if a signing agreement is in there, now I said the call parliament before it becomes effective. For parliamentary approval, there is a condition precedent for any agreement in Ghana. The Ghana laws, yes, say if the agreement is a foreign company, even if you join the agreement, but it's so parliamentary, you must still go at 181 plus 5. The implication is that even if the agreement has not gone to parliament, for parliament to approve, now what's an agreement with the That's the terminate here. The other party, no, who has not had this agreement obtaining parliamentary approval, can still claim all the sums that have been given to the company based on this clause 2A and B.
But for me,
so that argument, no, court shooting it down, and they even, if you look at page 143 of the award, this is so. I'm sure that my interpretation is wrong because the agreement that we signed, Chese, under clause 3, which also repeats the same things in clause 2. We're supposed to pay.
Yeah. Honorable, that's say mono in my defense, no, mo hate clause 1. I can say so my meet condition precedent be a mutimi HM.
The agreement is
no more raising
clause
2A and 2B and as well as clause 3. Any 25.
But this is what we have signed as on my
Yes.
But Obi Fachemi, are we sure we are reading the right document?
100%. Correct. 100%. This is it. Government of Ghana represented by the Minister of Power.
At the time,
yes, there was no Minister of Power in our time. There's never been a Minister of Power in our time. No more Minister of Power. And GPGC Limited, emergency purchase agreement. Now look here. Says the emergency purchase agreement, this agreement is entered into as of this 3rd day of June 2015 by and between the government of Ghana, represented by the Minister for Power or its authorized representative, having its principal office, so and so, and GPGC Limited, a private limited company incorporated in Ghana, so and so. Okay. Of course, the company was owned by foreigners and all that. Then the signature page for the agreement also indicates quite clearly those who signed it. So, I mean, there's no doubt. This is, so, in witness whereof, the parties have executed and delivered this EPA as the day and the year first above written. For on behalf of the government of Ghana, Dr. Komna Donko, title Minister for Power. So, on behalf of GPGC.
Okay. Dr.
So, but Honorable, my question then, following from revelation, I would say, because Yenim says, Oko into international agreements, anyway, you're cool, mono. Not for reasons being Opesa will terminate here. The other party or no will be at the receiving end of the termination. No, our right to be on bit my exercise. It been so call to the tribunal in the UK. When we advised the Ministry of Energy and go ahead and terminate the contract, no, were we aware of these other clauses? Say you could terminate, that's a could do court. Near is okay, we terminated based on the fact that condition prisoner also meet your money and meet and terminate here. Did we know of the clause 2 and 3 and the provisions thereof?
Yes, I mean, it was there quite clearly.
So why then did we recommend saying
because of the same reasons, if we deliver it, it was going to result in excess capacity. Then the committee also made the finding that agreements in terms of the tariffs, that's charges too high. Into indemnity. Into what is our PP committee report now? In some can say indemnity a 80 million.
Yes.
I think no credit maker. I think it's a part of the was wrong. It was wrong. Maybe I know many lawyers in here, but it did not take into account the relevant provisions of the agreement. Yes, and that's what the tribunal actually stated. In fact, when Dr. Hinkra was in the box and when another gentleman from Ministry of Energy was also in the box, all these things were put to them. So we had experts from Ministry of Energy, enter Adakan,
as witness for the state.
Yes, dancing. There's also experts be also making calculations. So no, what they were entitled to is not 134 million, but about 68 million in all total. But the committee, the tribunal preferred the testimony of what GPGs for the file. So that's it.
And you know, 134 million. Okay.
Honorable Inti, the ruling was delivered in January 2021. After the ruling, now you need any other options to either appeal, to either exercise any other right or not?
There be not at all. And I think it's a question here because first of all, the show timer, judgment. Judgment on 26 January 2021. I'm out for play mystery. Say, me not me cause
Yeah,
that time I was not even attending juror. There was actually no attending juror in office. The time the judgment was delivered. So that also might have accounted for all the difficulties and challenges. And there was no attending juror because by law, whenever attending juror, anywhere, whenever there's a vacuum in the office of attending juror and deputy attending juror, it is the solicitor general which
and the acting.
Who acts? Who acts? Because really, until here, time I appointed president's representatives around the country. Office of attending juror, there was no president's representative.
Not president representative be any.
Yes, because in Bra, you didn't president or didn't in Bra no Legal Service Act. Just say attending juror anyone, deputy attending juror anyone, solicitor general no act.
Solicitor general they also act.
So and it also it is not as if say your arbitral order and as arbitration judgment it would be a right of appeal.
Only right of appeal
at all. And the agreement is that we express it. And agreement to open as arbitration award they final. In fact, Ghana, we have an Alternative Dispute Resolution Act. And in it, if you look at it, it will indicate clearly, say, even local arbitration, you have award a final.
A final.
Which my appeal, or appeal to the High Court on very limited grounds.
Yes.
If I say, a panel no, they have no jurisdiction. And I be mama hearing. And I say, friends, there was corruption in the process. So we need any of these factors. You cannot really appeal. Now, let me show the provision. I think it said clause 28.
And where clause 28 of the
agreement that we signed.
The government of Ghana. Any
GPGC.
GPGC.
Okay.
Clause 28, which I say, clause 28, paragraph F is on dispute resolution.
Okay.
Now, of course, here, Roman numeral 16.
Okay.
Roman numeral 16 says that the matter shall be heard and decided and awards rendered by a panel of 3 arbitrators. GPC and the GOG shall select one, so and so. And then the venue for the situation. Okay. So Roman numeral 7 also, in arriving at the decision, the arbitrator shall consider the pertinent facts and circumstances and be guided by the terms and conditions of this agreement. They shall be guided by the terms and conditions of this agreement. And if a solution is not found in the terms of this agreement, the arbitrator shall apply the governing law of this agreement, which was Ghana law.
Yes.
But if the solution is the agreement, that's what they apply.
Yeah.
Until the Mkazu, some 80 million Makande, an agreement, they should pay more than 100 million.
Yeah.
Now, the decision of the arbitrator shall be final and binding upon both parties, and neither party shall seek recourse to a law court or other authorities to appeal for revisions of such decision.
Neither party can seek redress at any law court following the decision of the arbitration panel. No? But in Ghana government, it was
but English arbitrators, English Arbitration Act, English Arbitration Act of 1996 shows that a party may have a window of an appeal in there by alluding to certain factors of illegality and that kind of thing, maybe a violation of the procedure. Now, in February 2021, again, I was not that injured, and as I said, I need any public office at all.
Yeah.
Because so I was just at home, but I'm unfortunately I'm Diago, so I'm unemployed. Because really I was not deputy attendant, I was nothing, I was just at home in doing my own private things. Then apparently, this law firm, Omnia Strategy, LLP, headed by Sherry Blair, Tony Blair's wife, QC, very top lawyer, not because of Tony Blair's wife, like I said, in your own right, or a lawyer, powerful lawyer, UK, or BNM, no, QC, and all that. And got in touch with the government of Ghana and said, represented to the government that they could file an appeal or they could explore the possibility of filing a challenge. Now, President, is it an all along, we hear many arbitral awards against the government of Ghana. It's not the first time I hear an award against us. Balkan Energy.
Yeah, Balkan Energy.
NDC time, we have judgment debt against us. Arbitration award, $30 million or so. I don't know, they didn't do anything at all. They didn't file any appeal at all. They didn't file any challenge. They just allowed it. You try. If you buy administration it's more because almost at least is here normal around the world. The company which won, science is assets around us, we're compelled to pay. Now, I don't say no because of young challenge, you know, and it's so beyond concept.
Yeah.
By now they say okay, it's all just taking it or there's letting sleeping dogs lie and for us to quietly accept the award. You know, we're going to explore the possibility of a challenge. Now, I buy no at that time. Instructed say there should be a challenge. So that decision, maybe as I told you, the office was headed by the Solicitor General, but that's fine. So the point was made, say, sir, challenge and and you say you're right, but the agreement says it's final and binding upon you. You have no right to appeal. So it's just an extra mile. It's an extra mile that we were trying to go for the nation. So I don't see why an imponent if travel like as a Ghana for Becca, travel like Nasa here, and it should be a problem. But interestingly, in the court, no Emma shall blame more up to 8th match. Someone filed a challenge. By 7th match, then they themselves came up. So, Omashe Adna intimate.
You filed a challenge name
Now, I was appointed as a tenderer on 5th March. It was a Friday, 6th March, Saturday. And therefore, Monday, 8th March, also statutory holiday in Ghana. So my first day at work was 9th March. The 9th March, when God brought I actually sought for a meeting with the president, and I broke the news to him that this is the situation and all. So, hey, really? How? Now, it's a work. I'm surprised. Why raise you hope so? They can appeal this way and so. Now, for the day before, I was into me appealing now. Young settle now. Wait me up boy and settle. I mean, one can very a little bit.
And day before no was in the 30 days window now near war to file anyway after the ruling.
No.
Okay.
That was within the extension of time and now.
Extension of time.
Do get a point. And that was actually a day before, also Sunday. Sunday. And the actual expiry of the time given to them was also on a holiday in Ghana, statutory, that's 6 March. So, if she had formed a view initially, say, a bit me appeal here. Maybe not possible. Maybe let's try some other lawyers. And Robert Votera Theatre, very strong law firm, equally strong. Many offices around the world, many lawyers. We call internet Mugogila. With the caliber of lawyer, represented many nations, many countries, Asia, and that kind of thing. So you can tell that in South America and all that. So really, this country beat me about. So it beat me. I explore Nyari, we call the grounds can be. Okay, so what grounds beat my important bisa no? So see, a man all the circumstances. So then which my your late appointment as a tenderer, the time I there was no tenderer, Gofred and all that, and that also the bureaucratic system and all that. Yeah, no Friday. It's okay.
Now, canvases our grounds, no, to drum home what point? The point
that no, you must explain why. Yes, you are asking for extension of time, so you must explain why you couldn't satisfy the earlier extension of time.
Okay.
But that reason is purely accounted for by the default of one lawyer who waited until the last day to say so. But in any case, even that one, even if that application had been filed out, a loan say was going to be granted. Yeah. Because really, that application was to question why the award was given within the very strict confines of the principles that are indicated to you. It's a lack of duration. Yeah. That was duration. A tribunal, the agreement entered into by a commander gave them duration. That there was corruption. I did not see any corruption in the process of the arbitration or and even such a tall order. There's actually, it's like maybe 1 out of 1,000 cases. Recent one was a Nigerian case, what I looked at this, this is different. Then so to almost try, so we have to convince it. We said, okay, the failure of the arbitration panel to consider our points, under the agreement, they are entitled to this small amount, 68 million, and all that. So they didn't consider that adequately, and therefore they didn't carry out the arbitration in accordance with the proceedings or procedure set out in the arbitration document, and therefore we should be entitled to having it set aside. So the tribunal consider all this point. Tribunal came to conclusion, well, even that point, it's not one of procedure. It's just, so really, that was it. That's it. The point is that after 26 January, Ghana buying now you need the right of appeal. Now, as somebody said, the horse had already bolted into all the things that were done. Now, extra steps. We're just trying our luck to see it will happen. That's pure.
Honorable, to the best of your ability, so we should defense I mount here in 2020. You think, sir, not the best defense we could have mounted?
100%. All the various grounds, yes, vigorously contested and all. Yes, I mean, and the proceedings are there. Sure. Yes, I can actually try and maybe finish later on with the processes, the pleadings, the closing argument. Arbitration, a very tedious process. It's not like court give motion, and then my lord so now application cancel or dismiss. In this case, even after valid evidence or witnesses, we have to even argue orally. They'll give you a lot of time, about 4 hours or 3 hours. It's not like Ghana because it be 5 minutes.
5 minutes.
No, 10 minutes for each side. No, at all. And even that one, it is preceded by what they call skeleton argument. Skeleton argument here about 30 pages. Skeleton prepare the various points of argument. You examine it one by one. And that's it. So really,
Yakasepi.
And from the skeleton,
Yakasepi. Bottom line is Ghana aboka from Yankomo and keep it me avoid it. Is that correct?
Yes, I think it may avoid it because right from the beginning agreement
It is a day in Ghana about it.
Well, as indicated, I think that the conduct of certain public actors ought to be examined. You cannot be entrusted with public power and exercise the discretion that you vested with in the manner that you desire. If you have to enter into agreement, as soon as the agreement say here and I say here, you don't go into it. If whether here or not, person set terms of negotiating a year. So we must investigate, we must carry out an inquiry to find out what happened and all. And I think that's what happened. Now refer it to the appropriate investigative authorities, the CID, Criminal Investigations Department, for me, equipped to carry out such an exercise. And then those who may be culpable, we will see.
Maybe start the question. Investigations now can say very important, but shouldn't we have done some investigations even before mounting your defense, to be seized with all the facts and everything that happened? Now, it may inform me the kind of defense and give mounted.
This PPA committee was part of the process of investigation.
Okay.
No, but we know.
Okay.
Attend you another time as a share or advice termination. And I, in all humility, now I'm the attender.
Yes.
I think that it's still not too late. There is no time bar to the institution of criminal investigations or any criminal proceedings whatsoever. I think it's
because who follow proceedings and now defense accompanying so mount. For example, at a point they made the way say, even when the government of Ghana was saying condition precedent ni be a more meet, i.e. permit ko mu here to go and develop the site ewo temano or more permit. They proved assembly no emma or more permit. Number 2, at a point in time and PPA investigations near Kosovo. They claim the technical advisor to the minister Emma more constant assurances say momo the end there enya dia ye be twa mo contract name, and it was part of more issues we raise your court. I think ni nyina so boa
I think well, some questions we Minister of Energy for a bit, Makasa.
Okay.
Me, I am very much concerned about how sometimes Minister of Energy went time to such agreement. We are inheriting many of these energy agreements has the potential to result in financial loss. Your back could be on West African Gas Limited, and also unnecessary. You enter into it. There was no conditions precedent satisfied and all. Almost you have for $1.088 billion. So around the same time, I hear GPGC arbitration. Near yet, and also at the same time. And then they it me fight here the court awarded $68 million. So from $1.088 billion claim. Even though the court found the termination wrongful, we are inflated with only $68 million. And so they say for me, it constitutes very serious savings.
Yeah, significant. Very significant.
Has to be applauded, but nobody, of course, is talking about it. But it's a matter of record. I say a share how it me how you enter into agreement. And as I said, the main question should be one: who here? Now who here? So now we are a prime so we are so now we are so clauses no, they're very important. The termination clauses, consequences of termination, and all that. Even our recent referral to arbitration for me, if necessary, we should avoid it.
Marcelo, with the contract to do an officer and a Ghana contract to do. So there's a challenge. Yeah.
Do you have information, sir? Even this agreement, no, the AG then no issue okay BBA. More was information, no.
And I also have information showing say the address of even the company, no, first address. Well, actually, the office address of a deputy attorney general.
Oh, Debbie.
Yes, it's a matter of record as well.
Yeah, company GPGC. Our initial address, one of the deputy attorney generals.
A deputy attorney general.
Now the office address no more use.
Yes, okay, yes.
Wow.
And they were also supposed to go through the agreement and make sure, say, BBI Kama, the nation's interest is protected. And this is the kind of agreement we had. But the other point would be, sir, in CCA, BBI do CCA, no? Yes, yeah, a buyer and agreement say, oh, put it in a certain way to see, say, BBI, ebetime PM about anye. Until we have to pay the amount as determined by the arbitration panel. A buying between
170 million.
I mean, so and it's say well, it's 134 plus
134. Yeah.
So you know about 138. I don't know how I'm calculating almost 170. So when I'm calculating, I'm a mathematician. It's 170. I'm not
134.
So maybe no 134 plus I think cost of about 3.something million. So you know 138. And I'm saying interest. I can not speak to that, but we are still negotiating with the company. In fact, my finally challenging and negotiating. It's part of the strategies that we deployed. So we are still negotiating to them. Yeah, I think quite this.
But you had
oh yes, but
based on the
yes, but even the PPA committee can say to you. As with you right from beginning. Agreement and which is a terminate here, which you say. A PPA committee is just say a terminate here, a bit here.
But from the PPA committee in the no, we also say Omoka say May no, Omoka say Omoka 18 million, and one of the narratives are Mate and they say probably we should have gone for the option of paying the 18 million. Na ya hohoro say Monko, and now say yentwem to avoid paying per annum 20-something million per annum.
That 80 million and then may I cannot claim whom baby or me has 80 million. Yes. No, because the NHS say they will be entitled to the full cost of the agreement if we terminate at any point in time.
That's based on clause 2.
Yes, clause 2. B, you know? Yes, plus clause 25. But in Boma, tied to the full cost of the agreement. Wow. And it's the full cost agreement plus the expenses that they incurred in transporting the equipment to Ghana, the plants to Ghana. Yeah.
If I just say CID. Which public officers near they or Moko CID said they should be investigated?
As of most, it's not as if say me targeting a particular person.
Okay.
So CID investigator, we investigated all the circumstances
Okay.
surrounding the execution of the agreement and the terms and all that. Of course, one question that CID cannot ignore is who signed the agreement.
Why sign agreement? No. In this case, Dr.
Another-
Pablo
yes, another question.
Interested party. Okay.
Another question too then will be, what are the factors accounting for the execution of the agreement? Say, then sign this agreement. So. Now, thirdly too, say no, almost was it economical? Was it unduly expensive? And no. And some are investigating other matters. And see the investigations there. Even on those that you do not even suspect will be eventually.
Yeah.
We know we've chosen the route of CID because we suspect criminal will be a woman.
Yes, say we are all saying say if there was financial loss, then there must be
Criminal
yes,
investigation.
Yes, liability. Criminal liability. Yeah.
Ma yemfa seda ema omo a etie yen e wa Asempa 94.7 FM. Ekosiisen Jumedi no asugusu a utie de beda de Honorable Gofred yebo adame ase. Me ni your say mo so man hene kwabena sante na me bo mu me ni bo mu interview yi ebrem nti ye